Okay, guys. Sorry, it has been a terribly crazy day. I can't tell if it's live, it's spinning. Um, well, hopefully you guys can hear me. Okay, there, it looks like it's going live. Okay, so, um, I cannot believe it's already almost 5 o'clock. I thought it was 2 o'clock. It has been an insane day. Every single day so far in this, I thought I was busy, but today has by far exceeded every single day before in terms of the things that are all happening at once. So for those of you who are waiting for me at 4 o'clock, I am really sorry that I let you down on that. As soon as somebody said something to me about a Facebook Live video, I look and I'm like, oh my gosh, it is 4 o'clock, it is past 4 o'clock, and that's where I was supposed to be. So I am very sorry about that, guys. Let's see here. What I wanted to do, first of all, I am, give me just a second here, guys. Apparently, I can't change. That's weird. Nope. That's okay. Anyway, we'll see how this works. I'm trying to change something up here in the post itself, and it doesn't seem to be doing that. Oh my goodness, what is it doing? What on earth is my Facebook doing? Alright guys, hang in there with me. Okay, apparently I'm with no one. I started off being tagged with people, and now I'm not tagged with anyone. So, oh goodness. Okay, well, we'll roll with it. It is what it is. So, all right, let me see. I said I was going to answer questions for you. Okay. Thank you. I am trying hard. Try not to let you guys down. There's a lot of updates that have been happening, but they're not necessarily all related specifically to the petition, so I don't want to waste time on that right now if you guys have a lot of petition questions. Oh, well, I did file an amicus brief, so I guess I can just answer that. Yeah, I was tagged with Ruth. I was tagged with 12 people. I was tagged with 0 people. I don't know what it's doing. So I guess what I'm going to do is change the name of this, and we will just make it answering questions. So if you want to ask me questions, even if it's not about the petition, that's totally fine. Okay, so first question I see is, Mike, you're going to help me with questions, I assume? Yeah. Okay, so the first question is, what's up with the legislature's lawsuit? Did I file an amicus brief? I did file an amicus brief. And it was the very first time ever that I filed a brief without being able to print it and proofread the whole thing before filing. The very first time since Mike and I have met that I filed a brief without him proofreading it, and without me ever having anyone proofread it. So that was nerve-wracking. I had to do that because I don't honestly remember if I said any of this in a Facebook Live video, so I don't know if you guys know this, but I happened to get into contact with the court clerk on Friday afternoon, the Supreme Court clerk, and I was asking questions about something with that. I don't know exactly what I was asking him, but I was asking him questions that ended up leading to me realizing that although the Supreme Court had set the governor's attorney's response date at June 19th, meaning I thought I had quite a bit of time to write an amicus brief, they didn't officially move up deadlines, but the governor's attorney filed a response, and the legislature's attorney, of course, had filed not only their claim of appeal, but then they filed their request to jump over the Court of Appeals, essentially, their leave of appeal to the Michigan Supreme Court. But then they also filed a motion to have the case heard on immediate consideration. Well, the governor's attorney also filed basically the same documents. They filed a claim of appeal at the Court of Appeals, and then they filed a request to jump over the Court of Appeals and have the Supreme Court hear the case in a leave application for leave to appeal. And then they filed as well a motion to have the case heard on immediate consideration. There's also some appeals that were filed with the intervening parties, the 5 attorneys who were attempting to intervene in the case as a party. And I won't go into a ton of details, but amicus parties essentially are acting as a friend of the court, not child support friend of the court, but just essentially someone who can help aid the court in coming to a conclusion, either by introducing different legal arguments or factual arguments that would be helpful. So in any event, the interveners are asking to come in as an actual participating party. So essentially what their request is at the Court of Claims level was, we will sue the governor, and we were going to file our own lawsuit, but instead of having 2 lawsuits going down the same path with the same defendant, why not allow us to join as interveners so that we are essentially arguing all the same things, but essentially just allowing my husband's watch is ringing. That's a new problem. Essentially allowing both cases to go forward without having to waste all those judicial resources of having 2 cases actually going. So the Court of Claims judge denied them and did not allow them to participate as interveners, and so they appealed that. So was it last night that the ruling happened? Okay. So last night is when the ruling happened from the Michigan Supreme Court. So let me pause, I guess, because I'll say that. So Friday, when I found out that the parties had essentially all filed and they were requesting immediate consideration, there was nothing from the Supreme Court saying, okay, we intend to issue our decision by X date, so anybody who plans to file any briefing in this case has to file by this date. But I knew what it meant. So unfortunately, Friday, Saturday, Sunday, Friday was the day that I was finalizing things with the petition to amend the state constitution. Saturday was the first day that we actually had petitions in hand, and late Saturday evening is when we had our inaugural petition signing, and started getting petitions out in the hands of circulators. So it's obviously very busy Saturday and Sunday, and the first part of Monday, and our team is growing, and we have thousands of you reaching out, asking to be able to help in some way. You are helping me watch the comments, right?
Yeah, I'm looking.
Okay. So thousands of you have been reaching out and asking how you can help in some way, how you can get trained as a circulator, just in all kinds of different ways. And we totally appreciate it. I know I absolutely appreciate it. Being so blessed with such an immense response so quickly, I immediately asked for help from a wonderful guy named Tom, who's like one of our new best friends, even though we met like a week ago. And it was too overwhelming for the 2 of us to handle, and so we had another person added and another person added. As of today, we now have 3-4 new people to the team. So it's growing at exponential rates, which is great. For those of you, well, I'll get going on that in a minute, I guess. Anyway, so I was working on the petition, and so Monday it wasn't until, I don't even know, I want to say like 4 o'clock in the afternoon, I finally was able to sit down and start working on this brief. And I knew it was important, and quite honestly, I knew I was called to do it. So to me, if you're called to do something, there's no choice. It doesn't matter if it's tough. It doesn't matter if you're tired. It doesn't matter if you're hungry. It doesn't matter if you really just want to be outside in the sunshine or on the beach on the coast of Florida. You got to do it. So I started writing it and putting it together, and I was really hoping by maybe midnight or 1 a.m. I'd be done and I could review it and I could go to bed, but that didn't happen, and so I kept typing, and eventually 9 o'clock in the morning came, and my ride was here to take me to Newaygo so we could record the podcast episode with Kevin Skinner and Garrett Soldano. And anyway, that was, of course, that's the drive up there, right? So someone was driving me, and I was able to type. Thankfully, she was driving me so I could type and work on this brief in the car on my Chromebook. And at any rate, my internet connection wasn't working, and then her internet connection stopped working, and then there was a road torn up right before we were supposed to be able to get to where we were supposed to go, and then all the directions weren't working, and it was like Lemony Snicket's series of unfortunate events or something like that. At any rate, I show up to this woman's house in Bronson, because that's where I had to go after Newaygo, and I was supposed to do a presentation on this petition and how people can get trained, and I looked at her and I'm like, hi, I just got here. I'm so sorry that it took us forever to try to figure out how to get here since the road was literally torn up and our maps stopped working, Google Map and iPhone Map. But at any rate, I said, do you have a computer that has PDF capabilities and an internet signal? Because I have to convert my brief into a PDF, and I have to attach the PDF, appendices and get it uploaded. And I thought, no big deal, I could do that fairly quickly. And about every technological thing that could go wrong was going wrong. And so it was no longer 2:45. It became, 3:15 and 3:30 and 3:45 and then 3:50 and then 3:58, and I'm looking at the documents and I'm like, why is it not loading? And at any rate, the reason why that was so important is that Monday night I was notified by another attorney that they were going to be shutting down the Supreme Court filing website at 4 p.m. on Tuesday. So if I didn't get my brief in on 4 p.m. on Tuesday, it wasn't going in at all. So anyway, it went in, I think, at 4 o'clock on the dot. And man, that was a wild ride. It's a good thing I'm not a drinker, because I probably would have been drinking a lot that day. But I did get the brief filed. It's not a perfect brief. I never even got to finish finally proofreading it, and lo and behold, there are 2 typos. One's like a whole complete constitutional reference in plopped in the middle of a sentence. So, it's quite amusing, but at any rate, I did get it filed. So I can tell you that what happened in that case was last night at, I don't know, I want to say it was 7 o'clock at night. I did get a, let me just make sure I'm speaking accurately here. It was, oh, no, it's actually 2 o'clock in the afternoon. For some reason, it didn't come through on my phone until much later. But we did get a dispositive order on the case, and I did not get a chance to read the whole thing. The actual order itself, though, is not very hard to understand. The order I can read to you. The order itself is like, what, 3-4 sentences? It's the concurring opinions and dissenting opinions that take up the other 18 pages, which I have not completely read. But essentially what the order says is that there were 3 motions in front of the Supreme Court. There was a motion from each party, the legislature and the governor's office, to decide this issue very quickly. So to decide the issue of whether they can jump over the Court of Appeals quickly. And then the third motion in front of the Supreme Court was my motion to allow me to file my amicus brief. So the Supreme Court granted the motions for immediate consideration, and the Supreme Court granted my motion to allow me to file this amicus brief, as imperfect as it may have been. And the unfortunate thing is that the application for leave to appeal prior to the decision from the Court of Appeals. So if you were watching my late night Facebook video couple weeks ago, I mentioned, I believe it's Rule 7.303, Court Rule 7.303, that allows a party to request to be able to jump over the Court of Appeals and have the Supreme Court hear the case before the Court of Appeals issues a decision. That motion was denied. And they say it's, quote, because we are not persuaded that the questions presented should be reviewed by this court before consideration by the Court of Appeals. They also denied the motion for the interveners to get their entries docketed, which I didn't read the full motion that was filed by the interveners, just quite frankly because I ran out of time. But my assumption is the way that that was worded means that the Supreme Court is essentially not going to allow them to intervene either. I don't know if they're entirely precluded because I didn't read the whole motion to know exactly what the court was denying. But what that means is it's not a win for the governor. It's not a win for the legislature. They simply said we are not going to rule on this case until it has at least gone through the lower courts. And they didn't say they're going to totally deny hearing the case altogether. They simply said we're not going to hear this case right now because we believe it needs to go to the lower courts first. I guess I don't know why, because the official stance of the court ends at that sentence. That's it. So we could take some extrapolations based off of the concurring opinion. I believe it was by Justice Clement. Justice Bernstein did write his own concurring opinion that has 3 paragraphs, but Justice Clement wrote quite a long concurring opinion with a lot of footnotes, and Justice McCormick and Kavanaugh joined in her statement. So the fact that 3 of them out of the 7 are in concurrence on that opinion, it's as close as you're going to get to what the majority of the court believes. But, oh, my Facebook Live video is freezing. Mike, you might have to help out here. Okay, is that better? I don't know, I'm still kind of choppy. Okay, sorry guys. So,
I'll disconnect. Just in case that helps.
No, it's my CPU.
Oh.
It just doesn't have enough RAM, I guess. Okay, so we do have some questions. I just want to make sure it's not about the brief. Will you be able to file your amicus brief in the Court of Appeals? You know, I have never participated in a case where I filed a brief at the Supreme Court before I filed a brief at the Court of Appeals, and now the case is actually being heard at the Court of Appeals before being heard at the Supreme Court. I don't know. I don't know, honestly, if the fact that my motion was granted means that I'm officially allowed to remain as an amicus at this point and the Court of Appeals, and then when it comes back up, I'll have to look at the court rule. I'm not even sure there's a court rule specific to this point. But I assume I will be allowed to file an amicus brief. Quite frankly, I don't think any of the amicus briefs that were filed, even at the trial court level with the Court of Claims, I don't think any of those were denied. I think the only ones that were denied were the motion for the interveners. So I anticipate I'll be able to file. And guess what? I'll be able to proofread it this time. So that's exciting for me. So we have some questions here about the petition itself. So let's get back to that. So please explain what you mean by transparency. Ooh, that is a much bigger question. Let me come back to that because there's a lot with that. Do you have a shorter one? You're staring at me. Okay. Can you explain reason for abolishing the several courts? Okay, so I'm not actually abolishing several courts. Whoever asked that question, if you think I'm not answering it or if we're somehow not on the same wavelength, please feel free to add a clarifying statement or question that Mike can pass over to me. What I did is, so many of you might not know that in our court system right now, the typical courts we're aware of is we have a district court, we have a probate court, we have a circuit court. Those are all trial level courts. We have, well, in the Court of Claims, but that's a whole different issue. We have the Court of Appeal, the Court of Appeals, and then we have the Supreme Court. So district courts have I didn't even realize this, but they're actually not constitutional courts. They're statutory courts, meaning the Michigan Supreme Court, the Michigan Court of Appeals, the Circuit Court, the Probate Court, those are all constitutional courts, defined and operating and given a jurisdiction as defined by the actual Michigan State Constitution. The district court it was referred to in the Constitution as a court of limited jurisdiction, essentially created by statute. So what I did in this amendment is to take away statutory courts and make the district court an actual constitutional court. So what we would have is the Supreme Court as you know it, the Court of Appeals as you know it, and the three trial courts, Circuit Court, Probate Court, District Court, but they would all be constitutional courts, and Probate Court is, in some counties, already handling all of the child abuse, neglect cases, guardianship, like adult guardianship and conservatorship cases, juvenile guardianship cases, name changes, personal protection orders, divorces, custody, parenting time, child support. I feel like I'm forgetting something in there, but essentially the family issues, well, of course they do estate matters and whatnot. So those things are already done by a lot of probate courts around the state, but we're not consistent. In a lot of counties, the divorces and other matters like that are they're being done by circuit courts. So anyway, it's consolidating all those family things to a family law court. When you have different courts doing different things within the same family, you end up with competing interests, or you end up with situations where people are, it's too chaotic and it's disenfranchising. And there's, of course, more we could talk about with that, but on the criminal side, how many of you know, unless you're an attorney, how many of you know at what point a criminal case enters the district court? And then how many of you know at what point a case might transfer from the district court up to the circuit court? And what are the different aspects of hearings at those levels? I mean, I can go in a lot more detail if people have questions, but essentially anyone who's been through those experiences certainly doesn't feel like it's understandable, certainly doesn't feel like it's anything that they can truly participate in. And many, many, many people feel that their rights are being stripped, not just because of the outcome, but because of the process, and how the more confusing, the more disenfranchising something is, the more it's not going to feel like your rights are respected. So that's what that piece is for. Mike, did you get an answer from someone as to what they meant by that? Or the question about abolishing courts, I asked people, I asked whoever that was if I didn't quite answer what they were getting at, or... Okay, so I'm not abolishing courts. What I'm doing is I'm saying that the legislature is not in the business of the judicial actions. They don't need to be creating courts. Why do we need that many courts? I mean, although we had some specialty courts in Minnesota like we do here, like a drug court or a mental health court, it's not technically like a whole separate court. when I was practicing as an attorney in Minnesota, we had district court, and then you had Court of Appeals, and then you had the Supreme Court. That was it. So, did you get what?
No.
Okay. So, I would go to court, especially in the small areas. I'd go to court, and I'd be in front of the same judge all day long. So I might do public defender work in the morning, and I'd have 15 criminal hearings in the morning. And then I might have juvenile delinquency hearings in front of them in the late morning. And then the whole afternoon might be a hearing, an evidentiary hearing related to a divorce matter. It was the same trial court judge. So here we have it broken up into all these trial court systems, and a lot of people are just kind of used to, well, that's how it is. But why? So we can have separate courts, but let's be purposeful. So at any rate, I kind of talked about those two. The third one is, so circuit courts would be your general civil courts. So if you have landlord-tenant issues, if you have contract cases, I'm sure some of you might know right now that if you sue someone because they owe you $24,999, then you sue them in district court. But if they owe you $25,000, you have to sue them in circuit court. Or, you know, there's differences between small claims court and district court. And so there's just a variety of things where the more complicated we make it, the more layers of government, the more distanced the people are from the government services that are supposedly there for the sole purpose of protecting and securing their life, their liberty, and their property. And that is the only purpose of government. The government is there, it exists solely to secure our life, our liberty, and our property. So those aren't my words. I mean, those were kind of some famous words said about 250 or so years ago. Those words are true today. It's not the government's job to provide us with food or to, you know, give us careers as lifelong politicians or, you know, anything. The government's job is to secure our life, liberty, and property, and that's it. So this is streamlining things so people can participate in the process of making sure they have a right to their own life, their liberty, and their property. So explaining transparency, that is still a really long one. Is there a super quick one? Because I just don't want to... Okay. I was under the impression... Okay, fine. I'll just answer the transparency question because some of these are going to be longer anyway. So, okay, transparency. Do you know what the government is doing? Do you know why the governor is deciding to issue 175 orders? I know it's not 175 right now, but just give her a week. Do you know why the city manager or township supervisor in your community has made the decisions they're making? Do you know how to access the full minutes of the last meeting of the public body in your area, like the city council or the township board of trustees?
I'm on this back.
You want one of these back? Fine. Okay. So the answer is, I'm assuming, that you don't really know. Sometimes you can go ahead and get information. You can do a FOIA request. Maybe your the clerk, the city clerk in your city is super awesome about providing information. All you have to do is ask. Maybe you're in a community that's super proactive in getting information on their website. But you know what? I think Laura Williams, I think if you're the same Laura Williams, I think you had a question that was posed. Shoot. Anyway, if you're the same Laura Williams that posed a question earlier, please send that question now, because whatever it was important, and we needed to do a video about it, so might as well answer it now, and I think it related to the petition. I just can't remember off the top of my head what it is. Okay, so at any rate, transparency. Sorry, I started reading somebody else's question and my brain went to what they were asking about. So if you don't know why your government officials and employees are taking those certain actions, if you don't know what decisions they're making, let alone why they're making them, how can you properly participate in that process? This is a republic. This is a government where we, the people, have the sovereign power, and specifically all political power is inherent in the people in the state of Michigan under our Constitution. So if you don't have that transparency, if you don't know what they're making decisions for, why they're doing things, or what decisions they've even made, how can you possibly participate in that process? So we do have the FOIA, we do have the Freedom of Information Act, we do have the Open Meetings Act. There are 2 other acts about, I don't know, I've said them in a recent Facebook Live video, but essentially geared towards transparency in government and allowing people to fully participate. So all of those things are geared towards allowing people to participate. So when you have accessibility, government accessibility, when you have government accountability, when you have governmental transparency, that's when it can really, truly return to more of a government by the people and not just a government of lawyers and politicians. So if you are missing any of those things, if you can't hold them accountable, you can see what they're doing, you can access it, but you can't hold them accountable. You don't have a government by the people. If you can have a system set up to hold them accountable, but you don't have the transparency piece to be able to understand or prove what it is that they're doing that's even wrong, that's not a government by the people. If you don't have accessibility, if you don't have the ability to seriously participate or meaningfully participate in any way, then you don't have a government by the people. When you have a governor who thinks that with a stroke of a pen, she can take away everything that's in the Freedom of Information Act and the Open Meetings Act, you don't have a government by the people. I mean, then we're just under a monarchy. But often we're done wrong by our legislature or the courts. So we need transparency, we need accountability, and we need accessibility. So I put right in there provisions of what it means to have that open government, that government by the people. And are some of those provisions specific? Yes. Have some people said to me, well, those really need to just be in a statute. Those need to not be in the Constitution. They're too specific. They should be in a statute. Well, I think they're important enough and vital enough that they belong in the Constitution. If it goes to the very essence of the form of government we have, then it belongs in the Constitution. Because if you don't have accessibility, transparency, and accountability, you literally do not have a government by the people. So if you're looking for specifics about what that means, well, governments have to post all of their, where's the text? Let's see. There's essentially all the meat from the Open Meetings Act and the Freedom of Information Act got put in here. And there's some additional things in here. In fact, where is... Oh, I'm looking at the wrong page. Okay. So, every single vote that affects us, so if it's a vote to, say, extend the state of emergency, that should be a vote that's taken by roll call vote. That's not something that they should be able to hide behind. If they're representing us, then there should be that element of accountability and accessibility, and so we need to be able to know what our representatives are voting on and why they're voting that way. And quite frankly, if they think it's a good vote, if they think they did the right thing, why would they have to hide behind a voice vote? They should be able to vote with a roll call vote and be able to stand by that. If they don't feel comfortable putting their name next to their vote, then they've done the wrong thing. So that's one of the provisions in here. I don't know how many of you have ever tried to get into contact with your any agency of government, but I could tell you that in trying to contact the local law enforcement agencies around the state and the local prosecuting attorneys around the state, getting accurate email addresses in this day and age should not be that hard, especially for government employees. And yet it was near impossible. Even the list that, let's see, what database was it? I don't know. It's like the Mackinac Center or somebody else had a database. Even theirs was totally out of date. I mean, totally out of date. So how is that? How is that okay? That it's something as so simple as maintaining email addresses. Like, for example, if you are the chief of police, why couldn't the email address be chief@beldingpolice.org or whatever the website is? There's no need to make this complicated. So that is something that goes into here. I was trying to find the exact provisions, but basically, darn. Mike, do you know what that provision is that I'm trying to find? Okay. So within 30 days of the enactment of this amendment, so when this passes, that would be November 3rd. So we're talking 45 days after that is when it gets enacted. That's what the Constitution says with any constitutional changes or amendments. Within 30 days of the enactment of this amendment, so essentially 75 days from November 3rd, every public body, court that's authorized by this Constitution, and public official of this state shall create and maintain an official website. The website shall conspicuously display the office email address, the sole email address used for the performance of official functions, and phone number of each public official. If you're a public official and you're being paid with my tax dollars, and you're supposedly doing a job that is somehow related to securing my life, my liberty, or my property, I should be able to reach you. So, phone number and email address. And then I lost where I was just taking it from. So, the name, the title, and the job description of each public official, that's not something that should be changing. I mean, the name and the name might when people come in and out, but the general job title and the general job description, shouldn't we, as people, government by the people, shouldn't we be able to look at the government website and go, I'm having this particular issue. I need to be able to figure out who in government this particular issue relates to. Like, who do I call? Which department do I call? Which particular employee or public official do I call? And more times than not, you can't quite figure that out, and you're bounced around to various places. So there's no reason why we can't have a brief description of what each person's role would be, so we know who to call. First of all, it's also going to help reduce the amount of inappropriate calls that are being made to the wrong place, if we can at least give the public a heads up of what each department or what each particular public official is supposed to be doing. Anyway, there's a lot more provisions in there that deal with that kind of thing, where we're increasing transparency and we're not requiring for a lot of the key things that don't happen, a lot of the key things that happen these days. It shouldn't be up to an individual to place a Freedom of Information Act request. It should be up to the governing body to make that information public from the get-go. Why should people have to do a Freedom of Information Act request for some minutes for a recent city council meeting or a downtown development authority meeting? I don't think they should have to do that. I think if it's matters that are affecting the general public like that, we as the public should have access to that. We shouldn't have to pay for it. We shouldn't have to ask for it. It should just be available for people. I can answer more questions about the transparency issue, but I feel like I've spent a ton of time on it, so I just want to start answering some other questions. I answered all those, I think, right? Okay, I was under the impression that the Court of Appeals takes several months to hear a case. Is that going to happen here? They can essentially file the same requests. So just like they did at the trial court level, which was the Court of Claims, they can file a request to have the case heard in an expeditious manner. So they can file a motion for immediate consideration, the same that they filed down below at the Court of Claims and up above at the Supreme Court. And it's not guaranteed to happen, but I would think that there would be some sense of urgency unless they're going to chicken out on the issue and they really don't want to have to deal with it. They want to wait it out to see if the governor is just going to start doing the right thing. Well, I guess we'll see. In regards to... What is this question? Is that really what they said? That doesn't seem like...
In regards to the abolition of the Civil Rights Commission, the AG is to take up... Is the AG to take up any of the allegations?
Is that how they said it, or are you paraphrasing what they said?
No, I think that's the same wording.
Okay, hopefully this was really your question. I just want to make sure. So I think the question was simply, with the abolishment of the Civil Rights Commission, does that mean the Attorney General is the one that's supposed to take up those allegations? Yes, the Attorney General is supposed to do her job. I'm not sure why we would need to create a Civil Rights Commission, which, by the way, was exercising delegated powers from each of the three branches that should never be delegated in the first place. But that they were exercising delegated powers of the executive branch, of the legislative branch, and of the judicial branch. All the powers in one place. That could never go wrong. So there was an issue with that from the beginning. Not to mention that those are people appointed by the governor, those that serve on the Civil Rights Commission. Those are not elected officials. Why do they get to serve in any kind of judicial, executive, or legislative position at all when they're not even elected by the people? So the answer, if the question is truly, is the Attorney General just supposed to be the one who is enforcing the laws of the state, including civil rights laws and constitutional provisions such as those found in the Constitution? Yes, that is literally the job of the Attorney General. That is the job. The job description is to enforce the laws of the state of Michigan and the constitutional provisions of the Michigan Constitution, as well as the applicable provisions of the U.S. Constitution. That is literally the job description of the Attorney General, and so that is what I believe would be most appropriate here. And I don't mean sarcasm to whoever's asking this question. I'm getting irritated thinking about the fact that that is the whole job of the Attorney General, who is making who knows how much money of our hard-earned tax dollars, and yet she's not doing her job. So I apologize if it came out to you, the person asking the question, if I was frustrated to you for asking. Absolutely not. It's a great question. Frustrated at the Attorney General who's not doing her job. So, okay, are there any more questions? Oh, I do have a question. What?
Yeah, you have,
are they all in there?
there's two in here.
Okay.
That one, and then
Okay, so I have a question from, okay, expecting probate to handle a huge caseload they are not set up to handle. So I'm not sure how our probate would be able to handle neglect and family matters outside of what they handle now. The way that it's set up first of all, great question, and I mean, I don't mean this in a condescending way, excellent critical thinking skills, because it is those logistical considerations are the very types of things that I'm addressing through this and that are very important. We can't just have something that works on paper and doesn't work in reality, right? So I appreciate this question. So the problem with the the way that I guess the question comes is that it's starting with the assumption that all the other things that we know and love, or not love, know and are used to about our government are, that they are, they're going to stay in place, and that they're a proper way to handle things. There's a lot about our court systems that don't function properly right now as it is. There's certainly a lot about our what do you need that for? What? He's taking away the questions I was trying to answer. So there's a lot about our courts that are not functioning right now very properly. And I don't mean this to you, the person who asked me this question as an employee of the front of the court. I don't mean this to you because I don't think I know who you are. Maybe I do. I'm not really looking at that. But in general, in many of the cases I've been involved in at the front of the court, and I will say from different angles, I've represented obviously a lot of dads as a, either in a divorce case or parenting time, custody, whatever. I've also represented a lot of moms. I've represented victims of domestic violence. I've represented, situations where people getting divorced and they don't even have kids. It's just a property issue, you name it. I've also come in and served, though, as a guardian ad litem in both the juvenile courts as well as the family courts. And I've done that since being in Minnesota. I guess I started doing that work 14 years ago, if I'm doing my math right, at least 14 years ago. And so I come, from that perspective, for those of you who don't know, a guardian ad litem, well, in Minnesota, it's a guardian ad litem and not a lawyer for the child. They're two separate roles. So a guardian ad litem is the person who comes in as the child's advocate, not their attorney, not their legal advocate. Someone who comes in and does an independent investigation into the situation with the child. Someone who, in Minnesota, you are trained specifically by the Supreme Court, and you are required to do your total independent investigation. You never are allowed to simply look at what the DHS or CPS officers have to say in the case. You interview DHS, you interview teachers, you interview counselors and foster care, foster parents. You interview neighbors, you review school records on your own, you talk to the counselors and you talk to the child's friends, you talk to the parents, you talk to the child, you talk to everyone, and you do your own independent investigation. And then if the child, at least as the time that I was practicing there, it's a little different now, but when I was practicing, if the child was at least 10 years of age or older, they would have their own attorney as well. And so I have served as both an attorney and a guardian ad litem for children in Minnesota. And there's a family court version, and then there is a juvenile court version, just like we have here. The only difference is here, a guardian ad litem, although you can technically have a guardian ad litem who is not the lawyer for the children in a case, the most common situation is that there are lawyer guardian ad litems, or LGALs, assigned to cases. And so you are in this role where you were supposed to independently investigate, but also advocate the legal perspective from the child's eyes, basically. So from that perspective, that's what I'm bringing to the table. That is, there's just a lot that is happening in front of the court offices across the state that should not be happening. In fact, I would say the biggest problem is that instead of just acting as a mere source of like a layer of alternative dispute resolution before parties can get to a court, instead of acting as a mere a funneling of information so we can, maybe narrow down the issues for trial and allow the parties to, exchange information and get to the point where the mess of it all is not just done in a trial court setting, which essentially is what the front of the court should be all about. The front of the court in many counties is like, that's it. The buck stops there. You have everything done there. And there is, some judges, circuit court judges, will just rubber stamp what happens at the front of the court. That's not appropriate. That's not what it's set up for. Those positions are not elected. People are being disenfranchised when it comes to matters of their very own families. So, would our probate courts be overwhelmed, those who are not already currently taking on those kinds of cases, by taking on these cases? I would say to you that the way we're doing it right now, most of these courts are very overwhelmed, but the people are even more overwhelmed. And when it comes to whether the government should be overwhelmed or the people should be overwhelmed, hands down, the government can be overwhelmed, but the people should not bear the burden of how the government is mismanaging the functions that it's supposed to be handling. So there's a lot that goes into the question that was asked about that, and it's basically a discussion that we could go into for hours, and I would totally be fine with that. Whoever you are, if you wanted to call me sometime and we can do that, that's fine. But essentially, the answer is yes, I agree that they would be overwhelmed if we kept the notions that all the other pieces would keep functioning the same way, and they would not. So the amount of staff that probate courts have right now would obviously have to change. Things would be moving around. I mean, quite frankly, for the counties that have divorce cases in the circuit court right now, and then they have the appropriate level of staff and other internal procedures to move those cases along, all of those resources would move with the caseload. And so, at any rate, I can answer more, I could talk more in depth, but I feel like at this point I'm probably going to be verging on something that people that are not working in the court system, I'm going to start to lose them and bore them. And so whoever you were, if you wanted to call me and talk about that, or, meet sometime in person and we can hash that out or answer any questions or hear the concerns, I would love to do that. I just feel like I want to be fair to everybody and not go on for an eternity on that. Oh, I thought this... Do I not have any more questions? I thought you said I had 2 questions on here.
I'm trying to put out a different fire here.
Related to what?
We'll talk about it.
Anything I need to address on here? Okay, so let's see. This question, no administrative officer. Am I correct in assuming that this covers things like contact tracing and tracing people by their cell phones? Okay, so the question is, am I stepping on you? Is that a chair or am I stepping on you? Okay. So this is about the section on administrative action where it states no administrative officer or agency may act to affect the private rights or licenses of individuals. So the question is, am I correct in assuming that this covers things like contact tracing and tracking people by their cell phones? The only thing that's hard for me to answer right now is that I've been so focused on the elements of government as it has been functioning to the point I started writing all this, that I haven't been keeping up on the specifics about how contact tracing is happening, or how contact tracing is being applied. So if it's being applied through an administrative body, then the answer is yes, that would be correct. That's the mechanism, or one of the mechanisms that would essentially shut that down. But if there was a statute that was passed, or it was done in some other way, then no, it wouldn't necessarily fall under that particular paragraph, because that's talking about the administrative agencies. So essentially, the Unemployment Insurance Agency and the Secretary of State's office, there's all kinds of different things where you start getting into a bunch of administrative rules, and then people, the average person, and 90% of attorneys start glossing over and going, huh? So we should not have such a disjointed system that people don't even understand that rules are being treated as though they have the full force and effect of law, when they're not with the laws. So you have to go chasing down all these other sources of information. No, if it's a law, then it should be a law. We should have our Constitution, and we should have our laws. And if they can't manage to somehow provide enough governance between the two, then perhaps they're trying to provide too much governance. Because this is a government by the people, not a government designed to control everyone. So, at any rate, hopefully that answered your question. Is that it? We're on here. There were only 2 questions on this one.
How do you think the legislators will react to having to write their own bills?
And I wish I could have suggested one bill, one topic. One bill, one topic is already in the Constitution. That's why the governor said, what is it? Article 4, Section 25. Do I have the Constitution right in front of me? I do. Article 4, Section 24 says that no law shall embrace more than one subject, which shall be expressed in its title. No bill shall be altered or amended on its passage through either house so as to change its original purpose as determined by its total content and not alone by its title. So, dare I say, let's use the example of Senate Bill 858. That was a great bill introduced by Senator Tom Barrett, and it was introduced with the sole purpose of reducing the number of days from 28 down to 14, that the governor would be able to exercise these emergency powers without first seeking an extension from the legislature. That's all that it did. It literally changed the 28-day time requirement down to a 14-day time requirement. It passed the it passed the Senate that way, went over to the House. The House put back in the 28 days. Then they decided that was the bill that they should be codifying 29 executive orders from Gretchen Whitmer in their entirety. Add a whole bunch of other provisions, including the mandatory wearing of face masks with no medical exception, and that the business owners across the state would be the ones responsible for enforcing the fact that people are supposed to wear masks regardless of any kind of health condition. So as you can see by Senate Bill 858, which somehow passed the House as amended like that and then went to the Senate and was astoundingly passed, that clearly covered more than one subject, which is why Governor Whitmer said she couldn't sign it and that she had to veto it. But it also completely altered its topic, its purpose, from the time it was introduced and passed to the time that it made it back through both houses as amended. So, anyway. So it's that part's in there. Okay, shoot. Too many comments. Where was the one? The question was about, okay. So how will they relate to or react to having to write their own bills? The ones that are currently there, well, there's a couple that I know would like to be able to just write their own bills without any pressure from leadership or, you know, the attorneys for the legislature. But I honestly don't know how they would feel. I think a lot of them would feel overwhelmed if they had to write their own bills. Isn't that a good thing, though? Wouldn't it be a good thing if a legislator had his pen in his hand? I realize it would be typed, not written, but anyway, if he had his pen in his hand and he's sitting down at the paper and he's deciding he's going to write out a new law for the people, shouldn't he feel nervous, overwhelmed, have this sense of urgency to make sure that he's getting it right? Shouldn't he be the one that writes it and understands it himself? And that way he can accurately explain it to somebody else? Because we know far too many legislators who are the authors of their bills, and then if you actually question them about their bills, say House Bill 5709, and you want to get down to understanding what's in there and why, and what is not in there and why, and they have to at some point pause the conversation and say, well, I just don't know the answer to that. I have to go ask our attorneys. Is this a government of attorneys? Did we elect those attorneys? Do we have direct communication or access to or transparency with those attorneys? Can we hold those attorneys accountable? No. So shouldn't it be the people that are changing our laws, creating new laws? Shouldn't it be those people, the ones that are supposed to represent us, that are the ones that are actually reading and writing the bills they're voting on? If you feel as a state rep that you are so overwhelmed by reading the statutes involved in a situation, then you do not need to be a state rep, because that you are the one who is writing and voting on the laws. If you don't feel qualified to read the ones already on the books, you do not need to be in a position to write new laws. Laws should not be drafted by attorneys just to simply be read by attorneys later on and then argued by attorneys later on and appealed by attorneys after that. Laws should be drafted by the people, for the people, in a manner that is understandable for the people and that applies equally and fairly to the people. And if that really seems like such a foreign concept to you that you think that's just not right, I would suggest to you that the entire concept of either democracy or a republic is actually what's foreign to you. Because in neither one of those, if you look up, open the dictionary or Black's Law Dictionary or historical books, nowhere does it say that it's supposed to be a government of attorneys and that we have to look to attorneys to explain everything. The reason why I sit here and do these Facebook Live videos with people is not because I think that attorneys should have to do that. I think we have to do it as attorneys now because our system is broken. Our government is broken. It's not functioning properly, and the average person, no matter how much education or intelligence they have, the average person cannot truly understand what our laws say, what our administrative and regulatory agencies are requiring them to do, what hoops they have to jump through to try to access information or hold government officials accountable. Does that really sound like a government of the people? A representative democracy? No. Just because it is the way that it is right now does not mean that it is the way that it was designed by the framers of the Constitution. It does not mean that it actually, what's happening now, even fits within the parameters of the Constitution. Just because there's been decades of court cases that decide that they're going to take an eraser to various aspects of the Constitution does not mean that that's the way that it should be, nor does it mean that that's the way that it has to be. This is a government by the people. You are all the people. You're equal people. I don't care if you have a JD behind your name or an MD or if you never graduated from high school. You could be a dropout. You could be somebody who has served 10 years in prison. You are a person. And we are all given inalienable rights, unalienable rights from God. We have the right to life, liberty, and property, and those are not just phrases. That is the essence, literally the entire foundation of our government. And its sole purpose is there to secure those very rights, not the rights of government. The government does not have rights. We do. We give the government authority to act in certain situations. But the government does not have rights. The rights aren't things that we can just create and give away. And no, they're given to us by God. So, with that entire system in mind, if you are thinking of running for state rep or for senator, and you don't feel qualified to read the laws we have, please do not run. If you feel like you want to run for state rep or you want to run for senator. And part of that reason is because we have too many darn laws on the books, and the laws are ridiculous, and they're aimed in great measure to reducing our individual freedoms and over-regulating the people. And you want to change that. You want to take that away because you don't understand the way that those complicated provisions are written right now. I can respect that. But if you're going to run with that in mind, when you get in office, don't sit there and say, I can't understand what this bill says. I need to talk to an attorney. If you cannot understand what the bill says, you need to be voting no. No. Because if you can't understand what it says without an attorney's advice, how do you expect the 90,000 people in your district to do so? That's what it boils down to. And I know, considering I've talked to a few state reps today who are not quite happy with me right now, if any of you don't like the fact I'm saying you need to be writing your own bills and you need to be reading every bill before you vote on it, if you think that I've somehow overstepped by saying that and calling you out, dude, let's do this as a Facebook Live. Let's let people hear exactly what I've done wrong by calling you out in that. I would love to hear what the explanation is as to why attorneys need to be drafting the statutes in our state. When they're supposed to be the rules governing the people, why are they not rules written by the people themselves? I worked hard for my law degree. I was a single mom. I had my son, got pregnant at 19 as a single mom. And it was hard. And some of my family thought I would never finish graduating from college, let alone go to law school. But I waddled on into William Mitchell College of Law to take my LSAT. I even got locked out of the second half because I was waddling around and my blood sugar was low and I needed to go to the bathroom because I had a child pressing on my bladder. And I simply could not pee and take another drink of water and then eat a small snack to get my blood pressure back, or not my blood pressure, my blood sugar back up. I could simply not accomplish all of that in the 3 minutes they gave us of this break. And so I just barely got to the door and the guy had shut it in my face and he made me stand there while they handed out every single other exam, and then he finally decided to open the door and let me in. And how embarrassing is that? I did it. And I carried my child around with me because I didn't have help and I couldn't get daycare. I couldn't afford daycare, but I couldn't even get it. I was on a waiting list. I carried my child around with me in that little car seat carrier thing with my winter coat because, Minnesota gets cold. And my laptop, which for those of you who are really young, laptops used to be extremely heavy and much bigger. And all my books, because most things were not actually on our computers or accessible on the internet back then. So my whole backpack and the diaper bag and the baby, and I trotted all around campus, bouncing my baby in the back of the classroom to try to keep him quiet and appeased so I can finish my classwork. And my son's aunt, once a week on Thursdays, would watch my son so I could go to my senior capstone course because that one was particularly not baby-friendly. And that's how I completed my college. And I did get into all of the schools in Minnesota that I applied to, and I chose to go to William Mitchell College of Law, and I was a single mom. And I worked up to 3 jobs at any given time while going to law school full time and had my son with me all the time. He didn't go to his dad's every other weekend. He didn't go every week. There'd be times he didn't see him for quite a while. It was hard and it sucked. I worked extremely hard and made a lot of sacrifices to earn that degree. Do I think you should have to earn a law degree in order to understand the rules by which you are governed? No. That is ridiculous. What was the next question? I'm sure there was something I should be answering.
I think you answered that one. I don't think I have one.
Really?
Hold on,
That can't be right. Did was it Laura Williams? Laura, you're there. Do you have that question? Are you the same Laura? There was a question. Can I have my phone? There was a there was a question that was important that we needed to answer at some point. Oh, whatever it was super important. I can't seem to find it. There is one important thing to note that before I was ready to go live and announce this constitutional amendment petition last Friday, my super zealous partner in crime, Kevin Skinner, was, we just had a miscommunication, and he kind of went live with a few details and a little bit more than what I was ready to go live with. And so there were some aspects of the version that was printed or distributed initially that aren't in the final version. So for those of you who have been either complaining ridiculously, nonstop about some grammatical errors or things of that nature, or, you know, various other things, I would just ask that you, oh shoot, Mike, we need to update the version that's on there, on the website. Anyway, the actual paper in hand petition is what we need to look at. So, to the extent that some of those people are commenting about different things, I just wanted to let you know those issues were indeed addressed. So I don't want you to worry about a lot of those things. There was another... Oh, yes. Okay, so someone, well, a couple state reps are not very happy with me because it's like 4,000 degrees in my office right now, so trying not to melt. They are not happy with me because I didn't go to the Board of Canvassers first with this petition. So, is that legally required? Nope. Not at all. Is doing a series of, what are they called? They're not called field studies. Mike, what's the words I'm looking for? You know what I mean? Where they do like focus groups and studies and all kinds of things like that. Is that required to do a constitutional amendment? No. Is it common that you need $2 million to be able to engage in the kind of research and work and you know, efforts that are truly needed? You got to be able to pay circulators to go around and collect all the signatures, and, you know, are those things common? Yes. Are they required? No. Do we have $2 million? No. If I had $2 million, I wouldn't be saying to people, please, if you believe in what we're doing, if you want to have your freedom back, please go to our website, restorefreedommi.com, and look at our donate button, or please consider writing us a check according to what the Michigan campaign finance laws require us to do. I wouldn't be asking for those things. But guess what? The people have stepped up because the people want their freedom back. We have people contributing, whether it's $5, whether it's $1,000. We have people contributing every single day towards getting these petitions printed so we can keep getting them in the hands of circulators who can keep getting them right in front of people to sign. We have an endless stream of people coming to sign, to circulate petitions, to sit at events to get petition signatures. It is a wonderful problem to have. In fact, our team has grown by 4 just today. I mean, in the last week, our team has grown. Well, I don't even know. I can't even count that high because especially if you're counting the captains and the circulators, I mean, it's in the hundreds, if not thousands. I personally don't know that information. Well, what we are doing is we do have things very systemized, and there's a method to the madness, that's for sure. And as we have the volume exponentially increasing, we are responding appropriately by immediately updating our systems. And that's all that can be asked of us. So the initial system that we had right from day one, we had a very organized method to handling the requests. But when it quickly became within 24 hours something that was much bigger than we expected right away, we made adjustments and brought on more people, and we're fine-tuning things. And so we're creating Google Forms to help facilitate the automation of the data that needs to come in so we can get the information quickly to people. So for those of you who are interested in becoming circulators, for those of you who are interested in becoming captains, regional captains, to help coordinate those circulators, for those of you who are interested in simply having your business being a signing hub where people can come from all over to your business and shop or eat or do whatever your business is and sign this petition, let us know by going to restorefreedommi.com and filling out that Google survey. That will give us all the information we'll need to know if you were trained, if you need to be trained, if you are able to pick up petitions from some place that's local to you, because we have places all over the state and that list is definitely growing, or if you're so far away from a particular petition depository, if you will, that we need to coordinate to get petitions to you. That's what this new system is created to do. In fact, we have so many people, just today alone, the amount of people messaging us about all the new events that we need to be attending. I mean, it's great. It's fabulous. Don't get me wrong. We now had to create a full-time position just to handle that. So we did that. And we will be updating our calendar. We're updating our whole website. Has that gone live or is that not live? Mike?
No.
When is it? Is there a time it's going to go?
I do not know.
Hopefully very soon. But I know there's a new website. It's going to have a lot more functionality that a lot of people around the state have been asking for. And it's going to be set up in such a way that I or one of the other members of the team can go and plug in information right away instead of having to send it to my dad, because he's obviously only one person himself. And so at the speed at which all of this information is moving and the amount of people are signing up and the amount of businesses are signing up to support this cause, we simply can't rely on one person to be able to have the time to plug in all that information. So we're doing a bunch of stuff to get improvements going in that manner, and we'll be rolling that out hopefully in the next couple days. Also, for those of you who want to get trained as circulators, and we're not doing as many in-person trainings anymore. You could still go get trained with Kevin Skinner. He is our guy for training, and he is the only way you can get trained to be a regional captain. The only way. If you have not been trained by Kevin Skinner to be a regional captain, you are not a regional captain yet. But as far as the circulating petitions goes, if you want to just be a circulator, then you can watch the video that I made. I do know from hearing constructive criticism from some people, one of you in particular, you know who you are, we responded, and I think, did you hear as to if the video is being made tonight? Actually right now, I think, right? Mike?
What's that?
Never mind, my husband's not listening to me. Those of you who are married, I'll just chuckled a little bit. So, Anyway, I did my absolute best to make that video on whatever it was, 2 nights ago, telling people how to, the training video. And so for those of you who thought that it was too long, or thought that you don't quite learn in such a conversational way, you wanted something that's more just bullet pointed or whatever, I engaged the services of two incredible guys that I met when I was, when I was speaking at the rally in Grand Rapids, put on by the fabulous American Patriot Rally group. And at any rate, I then appeared on their podcast, The Church Split. And so they are working on it, I literally think right now. I think they were going to start on it at about 6 o'clock tonight or 5 o'clock tonight, redoing that video in a way that's going to be shorter and more condensed and just kind of go through bullet point things. It's not very conversational. And so you'll have your opportunity to view whichever version you think is more helpful to you. But just to be clear, that is to just be a petition circulator. That is to give you the information that you need in order to go around and collect signatures. If you want to be a team leader or a captain, as we call them, a regional captain, you must be trained by Kevin Skinner himself. So hang out with the guy with the beard, and then you will be trained for that. There was something else I was going to say about that. Oh, well... At any rate, yeah, just to answer the question about does the law require you to get the Board of Canvassers or the Secretary of State to approve of the language beforehand, before you collect signatures? First of all, it does not allow you to get approval of the language of the entire thing beforehand. There's a big misconception there. It doesn't even allow you to do that. Let me find the correct constitutional provision, or excuse me, statutory provision. Okay. 168, MCL 168 482B 1 is a person who circulates a petition under 482. So we go to 482, and it talks about a constitutional amendment, an initiation of legislation, or a referendum of legislation. Okay, so those are the three types we're talking about. That a person who circulates a petition under one of those three kinds, that before circulating any petition may submit the summary of the purpose of the proposed amendment that is required under 482.3 to the Board of State Canvassers for approval as to the content of the summary. The summary. That's the 100-word summary, and mine is 98 words. So I could have submitted the summary for approval if I wanted to wait, what does it say, 30 days. But guess what? When God calls you to do something, say a week ago, which was, I don't even know what the date was. Do you know, Michael? Last Thursday, or last Friday. It was May something, wasn't it? May 29th? I'm going to say it was May 29th. I don't exactly have 30 days to send it off to them, wait for them to respond, and then start circulating the petitions for signatures, right? So it is not required, but it's to be clear, you are submitting the summary of the purpose of the proposed amendment for approval. You're not submitting the whole entire thing. So I know that there were some government officials out there telling people that you needed to have that done and that this petition is not valid without doing that, and that's not the case. So just wanted to clear that up. The first one... Okay, so the question is, the first part of the resolution describes not taking away constitutional rights. Are you watching these questions, honey? Okay. The first part of the resolution describes not taking away constitutional rights unless it's deemed necessary beyond a reasonable doubt. And the question is, this includes an emergency when decisions need to be made quickly? Absolutely. That's something that has been so... there has been this assumption by many people, and it's not necessarily tied to one political party. There's been this assumption that in times of emergency, our government gets to have all these extra powers that the Constitution does not specifically grant them. That's not what is allowed. The government is not given additional powers in times of emergency. Our Constitution itself was drafted in a time of emergency. The Constitution specifically accounts for times of peace and times of war. It accounts for all of the things that they had experienced up until that point. And it's not a living, breathing document in the sense that it gets just changed with whatever the circumstances of the day are. Our Constitution covers all circumstances unless it says it does not. That's regardless of any constitutional amendment. What my constitutional amendment does in that circumstance is simply to make it abundantly clear. Abundantly clear. So we don't even have somebody trying to argue otherwise. That our rights are not taken away, are not allowed to be taken away, are not allowed to be impinged upon in any way that violates the Constitution, regardless of whether it's a state of emergency. We don't lose our rights simply because of an emergency. Our Constitution does not change simply because of an emergency. The courts are not allowed to interpret and ad lib in times of emergency, more to the Constitution or less, however you want to read it, than what there would be when it's not an emergency. So we're well aware and well prepared for, there's emergencies every single day. COVID-19 is not the only emergency. We have babies being born early. We have people with heart attack or stroke. We have things happening with cancer or, other illnesses. We have car accidents and a variety of other things, mental health issues that lead to suicide attempts or overdoses. Am I saying that things should be done slowly? No. I mean, not necessarily. It depends on what you're talking about. What I am saying is it has to be done very carefully, very deliberately, and it has to be done within the confines of the Constitution, because at its core, the government's job is to protect and literally secure, those are the words, secure our life, liberty, and property. And to the extent that the government is going beyond that scope, it is acting outside of its bounds. So hopefully that answers the question. Did Laura ever, was her question answered? I can't see. I know she was one that had. And Stephanie, shoot, you asked me something or texted me something. I hope it wasn't something that I needed to address yet, because I just haven't gotten to all the text messages yet. Okay, so okay, just trying to see if anybody sent me questions that way. There's got to be. I'm sure there's always questions. You just said that we're the people. We are the people. I'm not sure. Did I misspeak on something? There's a question that says, wait, what? But you just said that we're the people. We are the people. We are the people. Yeah, 20,000 gun laws. Yeah. Okay. Do you mean... Why am I not able to read that? So what you're saying, okay, that's what she means to say. So what you're saying is that only lawyers can be a member of Congress. Wait, what? Did I say something that...
No, you were explaining that lawyers shouldn't be. I think that was a typo. Or she said it before you explained it.
Okay. if you still, Cindy, if you still have questions about that, if you still think that it is my position,
Oh, that was Cindy?
yeah.
Oh, okay.
If you still seem to think that lawyers should be, that I'm saying you have to be a lawyer to be a member of Congress, let me know, because that's not what I'm saying, and I'd be glad to clear that up for you. Okay, I see my husband's being called out. He must have been naughty. He got me all wound up about something, I guess. I don't know. Okay, so, oh, something about Carl I did not see. I see there's a news story that says that Carl won at the Supreme Court. I'll have to check that out. I also have some big news for you that will come hopefully in the next day or two. I will have a guest appearance by someone you probably would never expect. Hold on. So this comment says, the way our laws are written, most people can't understand them, which makes running for office impossible for most people, which our forefathers intended for everyone to be a part of. Exactly. And that's why there's a provision in there that when we have laws or restrictions placed upon the people, they have to be passed in a clearly understandable language. Because you're right. You can't participate if you don't understand what the laws and requirements are. What was the other? Anyway, so I was, there will be a very surprising guest appearance in the next couple days with me. We are going to talk about some very important and serious issues that are tied into this constitutional amendment. They are also tied into the brief that I wrote for the Michigan Supreme Court. So it's all related. But shoot, it just occurred to me there was a question that I heard earlier today that I was going to answer. Oh, someone recently asked me about, or stated to me that my petition here, this constitutional amendment petition, was going to fail or be turned down. I'm losing my wording here, but you know what I mean. That it was going to be turned down because it covers more than one subject. And so to those of you who have had that concern, that's not the case at all. The Constitution does not say you have to limit your constitutional amendment provisions to one specific subject. In fact, if you want to look it up for yourself, it is Article 12, Section 2 of our state constitution that discusses amendment by petition, an amendment of the Constitution. So the main difference is that what the question or the comment was going to is the difference between a constitutional amendment by petition, which is Article 12, Section 2, versus a general revision of the Constitution, which is done under Article 12, Section 3. So that is the that's the difference there. And for those of you who think that, there's been a lot of comments being made about it just being too general or it covers too many subjects. That you need to look at what the law says on that, what the Constitution says on that, and even the most recent court decision that goes into those specific discussions from the 2018 case when the redistricting constitutional amendment was challenged in court. Those are, that case specifically goes into all the reasons why a constitutional amendment, merely because it talks about different aspects, it touches on different aspects of the Constitution, or it involves various pieces of different provisions of the Constitution, that does not mean that it's not valid. So, just trying to answer that question.
Updated today, 6 p.m.
Oh, look at that. It's a picture of Ken with, oh, was he cutting hair on the Capitol? Is that what it is? I can't see.
No, this is Michigan.
Yeah, but what is that picture?
Yeah, that's at the Capitol.
What is he doing though? I can't see. Can you scroll that up?
Sure, he's cutting hair. He was there in Lansing.
But was that done at the day at the Capitol?
Yeah.
Oh, that wasn't done today?
No.
Oh, okay.
No, the article is just dated today.
Yeah.
June 5th.
Yeah, somebody
Michigan
posted
Post.
it right here in the comments.
Okay.
So yeah, I mentioned it, but it's the first time I heard about it, so I can't really comment on it. But it's great news for Carl. Absolutely great news. So there must be. Oh, it was kind of frozen. What? Okay. The question is, you're a victim too. You made a bad choice for husband. How can the citizens of Minnesota trust that you'll make good choices for them? You're a special individual.
Ouch.
I'm not in Minnesota, so clearly you don't know how to listen. How about we just get rid of you? Mike, would you mind just blocking whoever that lovely troll is? Listen to me. If you don't agree with me, that's fine. If you have constructive criticisms or even, total disagreements with me, that's totally fine. I can respect that. That is exactly the kind of thing that needs to happen, that kind of civilized dialogue back and forth. If you're just going to be insulting and downright stupid in your comments towards me, I'm just going to delete you because I don't have the time for that. So, sorry to those of you who I wasted time addressing her questions, thinking that they were actually legitimate concerns that I needed to clarify or try to address. So, is there, Mike, are there any more? I'm just reading the comments here. You guys crack me up.
Well, they're asking again, did the Supreme Court deny taking the case legislature versus Whitmer?
So, to those of you who are just tuning in now, what the Supreme Court did was they didn't deny to take the case completely. Like, they didn't say, this is never a case that we're going to hear. What they said is, well, we've decided that it is not appropriate at this point to allow this case to jump over the stage of being at the Court of Appeals. So they're essentially requiring the case to be heard out at the Court of Appeals first. And there's no reasoning by the court as a totality, because the order itself is the 3 or 4 sentences I read earlier. The explanations come in the 2 concurring opinions and 2 dissenting opinions, but of course that's not the majority of the court. There's no majority of the court who signed on to any particular outcome. Or I should say, there is no majority of the court that signed on to any particular description of why or explanation of why they arrived at that outcome. There is a majority that signed on simply to the actual outcome itself. Mike, I know there were questions that have been raised in some various groups. Oh, super important about the petitions. If you have not been trained by us, please do not try to circulate the petitions, because that is, we just want to make sure we're doing it the right way. It's very possible that you might have received the same exact information from a prior petition drive or effort that you were involved in, but we want to make sure we're doing this the right way. If you are trained and you have petitions, please do not give those petitions to other people to circulate if they have not been trained. We have a process for training people, and it's fairly simple and straightforward. All you have to do is go to the website, restorefreedommi.com, and there is a video for training. Once you've watched that video, you fill out the Google survey that will answer a bunch of questions that we need that information from you, and it'll let us know what the next steps for us would be as to whether we need to get petitions to you or whether you are able to get to one of our locations that are nearest to you. So with that in mind, I just want to remind you, please, I appreciate the zealousness, I really do, and where the heart is on those things, but I'm just going to ask that you please do not circulate petitions unless you've been trained by us. Okay. Oh, there's a question here that I'm just trying to think about this. The way that to answer this specific to this person, I just don't think would be appropriate to do in a Facebook Live video like this. But in general, it's dealing with the notion of having a private entity require you to wear a face mask in order to simply enter the establishment. And that is regardless of whether you have COPD or lung damage or any other, issues going on. And so therefore you are embarrassed and you are discriminated against. That's not okay. It's totally illegal. And those people definitely should be held accountable. Is that my primary focus right now? No. Unfortunately, we have bigger issues we need to deal with that involve trying to make sure that all of this never happens again. And so I'm not saying I'm not going to help on those, I don't want to say smaller issues, but those more individualized issues. Well, first of all, something like that is definitely addressed in this constitutional amendment. But as far as, whether I can help to sue a casino or Menards or whatnot, to the literally hundreds, if not thousands of people that have reached out and asked me to do that, I'm not saying no, but I'm saying not right now. I have to focus on this right now. Okay, so are there any other questions? Because I feel like sometimes as soon as we hit end, we get... Really? Yeah. Oh, what did I just do? Okay. 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 Anyway, I guess there were some comments made. I have a weird light on me now. What is that coming from? That's weird. Okay, I'm gonna just sit like this for a minute. Oh, it's good. It was just some sort of... Yeah, no, we're good. We're good. Yeah. It's like 5,000 degrees in here, so I'm trying to not melt everywhere. So there were basically some comments being made about, I guess, about the fact that I was a single mom, that being a single mom, or, essentially that meant that I have really poor decision-making abilities and, that I've made choices in my life that I shouldn't be proud of, yada, yada. Are you perfect? Do you know someone who's perfect? Because if you do, I really want to meet them. I'm not perfect. I will never be perfect. I know my husband's not perfect. Right, hon? For sure. So, my kids aren't perfect. Maybe Emma. No, she's not perfect either. I love all of my kids, even though they're not perfect. And I love all of my family, even though they're clearly not perfect. And I am going to fight for your constitutional rights, even though you're not perfect. Does that mean I'm going to leave you on my Facebook live stream to just comment and be a jerk and not be very productive in any way, shape, or form? No. But interesting that point came up, though, that even the people who have been kind of awful to me throughout the years... I won't finish that sentence. I don't take things personally like that. Whether we've gotten along in the past or not, whether you agree with me now or not, that's okay. I am going to fight for your constitutional rights because it's the right thing to do. And I am going to do the right thing, whether I'm doing it alone or with a team of people. And the great thing about it is at this point, God has blessed me with such a large, immense team of warriors, of freedom fighters, of people that never thought that they would stand up against a government action like this. I'm blessed to know those people. And it's going to take all of us working together to accomplish the kinds of changes that we need to accomplish. And we can do it. We're doing it already. So to anyone who thinks that we're disorganized or that we are, there's just no hope or we're not doing it the right way, you don't have to be on our side. It's okay. That's your right. But we are organized, and we're doing this because it's the right thing to do. It's not about winning. I had someone tell me today that at the end of the day, it's about whether we can win or not. It's not about whether we can win or not. It's about, are you doing the right thing? If you're doing the right thing, that's all you need to be doing. So as long as you're doing the right thing, whether you have people on your side or whether you have everyone against you, I hope you find comfort in knowing that you're really not alone, even though it might feel like you are. But certainly in this movement, you're not alone. There are so many people in every single community across this entire state. There's even people all across the nation that are reaching out to say they support what we are doing right now, where we are standing up to those in government who are going beyond what they are supposed to be doing, those who in government are acting outside of the scope of their governmental authority, who are impinging upon our rights. We're standing up for ourselves. We are not the ones rioting in the streets and breaking the windows of businesses. We are not the ones setting cop cars on fire. The very police that might have a week ago written one of us a ticket for not wearing a mask somewhere or for standing in a group of 20 people. We're not the ones that are advocating for violence. We're not the ones that need to go down that destructive road. We have the law on our side and the Constitution on our side, and this constitutional amendment is going to serve to further protect and further serve and enhance our liberties so that this can never happen again. So if you want to sit by and play the political game, you can do that. I'm done doing that. I'm not going to play the political game. I don't care who gets mad at me. I'm going to do the right thing no matter what. I would ask that you join me, especially if you serve in public office or you are an attorney, because if you have one of those two qualifications, that means you have sworn an oath to uphold the U.S. and Michigan constitutions. And I would ask you, I would urge you to stand beside me and fight for those constitutions. But with that, it looks like, well, my bar is frozen, so I can't tell if anybody has any questions. So it looks like all the questions have been answered, and I thank all of you for your support, and I ask you to consider helping us to circulate these petitions and get trained, and I wish you all a wonderful weekend, and just check back for the next live that I do with that little twist on some current situations. Thanks, guys. I don't think I can end my live. Michael, my screen's stuck.